National Security Hotline, 1-800-123-400. You see anything suspicious or untoward, you can ring that hotline and provide that information anonymously if need be. The government is, of course, always alert to ensure that our police and intelligence agencies have all the resources they need in order to keep our community safe. And as the Prime Minister and I have said many times, Australia's police and national security agencies are the best in the world. In the last 2 years, there have now been 4 terrorist incidents, but we have interdicted and prevented another 10 due to the skill and competence of our police and security agencies. This is a problem that will continue. One of the obligations of government is to ensure that the agencies have appropriate powers and that our laws are written in such a way as to keep the community safe. And it's for that reason that this week I will be introducing into the Parliament 2 new laws. These, I should stress, are not laws that are being introduced in response to yesterday's afternoon's event. These are laws that have been in preparation and the subject of consultation for a good while. The Counter-Terrorism Legislation Amendment Bill will, in particular, reform the laws in relation to control orders and, in particular, create a new category of control order for young people, people between the ages of 14 and 18. At the moment, the minimum age at which a control order can be applied for is 16. But sadly, we have seen terrorism events perpetrated in Australia by people as young as 14 years of age. So we will be extending the lower threshold, age threshold for control orders to 14 and making other important reforms to the control order regime as well. The other piece of legislation that I'll be introducing this week is the Criminal Code Amendment High-Risk Terrorism Offenders Bill. That bill was the subject of discussion between myself and my state and territory counterparts at the beginning of August. And what it will provide for is a uniform nationwide regime of post-sentence detention. Sadly, there are some cases where a person who has been convicted and imprisoned for a terrorism crime, after they have served their period of imprisonment, is nevertheless unreformed, is nevertheless just as determined to pursue their terrorist intentions as they were the day they entered the prison walls. We cannot allow, and we will not stand by to allow our society to be threatened by people of that kind. And so the regime of post-sentence detention will work so as to enable me, as the Commonwealth Attorney, to make an application to the Supreme Court of the state in which the person is detained for a post-sentence detention order. The court will need to be satisfied on the basis of admissible evidence and to a high degree of probability that there is a serious risk to the community of a repetition of terrorist violence by the person. And if the court is satisfied to that high standard of proof, it can order an indefinite period of post-sentence detention. This is not new. Most of the states and territories already have such laws in place in relation to serious sex offenders. And those laws were tested and upheld some years ago by the High Court. Some states, in particular New South Wales, extend that regime to serious violent offenders. The government has decided, and I'm pleased to say that we have the in-principle agreement of the governments of all of the states and territories, that that regime of post-sentence detention should be extended to violent terrorism offenders who meet the very strict criteria according to which it will operate. As the Prime Minister has said, as I've said many times, the government is determined to ensure that in an environment where the threat of terrorism is a given, sadly a fact of life, that our police and agencies will be resourced, both materially and also in terms of appropriate legal powers to do everything we can do to keep Australians safe. Thank you.
The 22-year-old at Minto, was he known to security agencies before the attack?
He was known to authorities, yes.
And what evidence is there to make you say today that there's evidence of some sort of ISIL connection?
That is the evidence. That is what I'm advised the police will allege on the basis, in particular, of material taken in execution of the search warrant.
Can you say what that material is?
It is ISIL-related material. Beyond that, I'd prefer, given that this matter is still an ongoing investigation, and not to be more specific. Thank you.
Sorry, I've got a few more questions. On the post-sentence detention orders that you just mentioned, you say that you will apply to the Supreme Court in the relevant states.
Yes.
If it is granted, will there be reviews of those orders along the way?
Yes, the orders will be for a period of time, and at any time, the person who is the subject of such an order can, of their own initiative, apply to have the order varied or set aside. So there are very, very thoroughgoing safeguards in place to protect the liberty of such people or the civil rights of such people. But nevertheless, if the court remains of the view that they, and the test is a high degree of probability, that they remain an unacceptable risk to the community even after the expiry of their period of sentence, then they can be detained.
Are there people that you're already expecting to make these applications for, and how many?
Look, there are people in prison at the moment for terrorism-related crimes whose sentences have not yet expired but will expire in the next year or two. Each case depends on its own particular facts, and for that reason you'll understand that it wouldn't be appropriate for me to speculate on whether these laws will in fact apply to any particular detainee.
On the gay marriage plebiscite, church leaders say that the Prime Minister promised money for both the yes and the no cases earlier this year. Are those church organisations being misleading about that?
Well, there's been a very thorough process of consultation with all interested stakeholder groups, both those who favour a change to the definition of marriage and those who oppose a change to the definition of marriage. And what those stakeholders have been told on all occasions is that in arranging or designing the architecture of this plebiscite, both points of view, the yes point of view and the no point of view, will be treated by the government with strict equality. Now, in relation to those details, that's a matter for the Cabinet and party room processes, which will be undertaken very soon.
Do you promise any funding at all to any of the churches?
I've made it clear that if there is public funding, it will be on the basis of equality.
Is it appropriate to even allocate funding?
Well, that's a decision that the Cabinet will deliberate upon and the party room will deliberate upon.
Are you still hoping to keep the cost of the plebiscite as low as possible?
We want to keep the cost of the plebiscite as low as it can be kept. This is obviously an expensive exercise, but we think an appropriate exercise, because if a decision, whatever the decision of the plebiscite is, it's very important that the entire community own it.
When will you introduce legislation?
Last question.
Well, the legislation will be introduced after the matter has been considered by Cabinet and by the government's party room processes. And as I said in answer to your earlier question, that will be very soon.
That's where we'll leave. Attorney General George Brandis speaking about counter-terrorism legislation that will be introduced to federal parliament this week. Senator Brandis said that he will introduce 2 new laws into parliament, which he outlined there to help deal with the threat of terrorism. He also spoke about a terror-inspired attack that happened in southwest Sydney yesterday. He said the man allegedly behind the attack is known to police and that it was inspired by the so-called Islamic State.